Welcome to our video on how to present evidence in Texas courts. This video is sponsored by the Texas Bar Foundation. Thank you for your support. The information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials available on this site are for general purposes only. Viewers should contact an attorney to obtain advice with respect to any particular legal matter. During our presentation, we will cover the different types of evidence, when to present evidence, and how to respond to objections. Evidence is used to prove the facts of your case. Different types of evidence include testimony, documents, including photographs and other written or typed evidence, physical evidence, and demonstrative evidence, which includes charts, maps, and diagrams. A person representing themselves in court is held to the same evidence standards as attorneys. You can find the evidence rules in Texas courts in the Texas Rules of Evidence. Pro se, or self-represented parties, should also become familiar with the Texas Rules of Civil Procedure and the Texas Civil Practice and Remedies Code. You do not need to attach your evidence when filing your original petition. Generally, you will present your evidence at your hearing or trial. Evidence must be presented to the court when a person is making their case. This is after opening statements and before closing statements. Opening statements is the time to preview your case to the court, but this is not the time to present evidence. Any evidence mentioned during opening statements will not be entered unless it is presented to the court while making your case. After both sides have made an opening statement, this is when you make your case. During this time, you will present evidence, call on witnesses, and tell your side of the story. It is important to present evidence while making your case because a judge can only decide a case based on the evidence the parties present during a case. Having evidence that supports your version of events is crucial in cases involving domestic violence. To admit evidence other than testimony, such as documents, physical evidence, and demonstrative evidence, you will ask the judge if the object can be admitted into evidence. An exhibit is any evidence other than a witness's testimony or words. It is usually labeled so that the court or other side can know what piece of evidence you are discussing. They are usually marked with letters, such as Exhibit A, Exhibit B, or numbers, such as Exhibit 1 or Exhibit 2. Some courts have local rules about how they want exhibits to be marked or how to exchange exhibit lists with the other side. Be sure to familiarize yourself with your court's local rules by checking your district clerk's website for a list of your court's local rules. Can you present any evidence in court? No, evidence must be relevant, material, authentic, and not privileged. Evidence must be relevant to the case and tend to prove or disprove a fact in dispute. Material evidence is evidence that is related to the issues in your case. Evidence is authentic when it is proven to be genuine, real, and not forged or fake. Some evidence can be authenticated by witness testimony. Other forms of evidence can be self-authenticating, meaning that they are considered authentic and require no further authentication, such as a certified public records. In court, you will need to authenticate photographs and text messages through testimony. Here are some examples of how this can be done. This is a photograph of a text message that this person sent to me on this date. My phone is capable of taking screenshots. I know that the text message is from blank because it came from his or her phone number. I have received a lot of text messages from him or her, so I know he or she writes and sounds like this. This photograph is a picture of the exact message I received on this date and has not been modified in any way. Lastly, evidence cannot be privileged. Information that is privileged does not have to be disclosed to the other party and cannot be asked about in testimony. Some examples of this is lawyer-client privilege, spousal privilege, doctor-patient privilege, and privilege for communications to a clergy member. There can be several different types of evidence depending on the situation. This might include things such as testimony, documents, physical or tangible evidence, and demonstrative evidence. Documents are commonly used as evidence. This includes, but is not limited to, police reports, diaries, photographs, text messages, social media messages, business records affidavits, and emails. To present text messages, emails, or social media messages to the court, take screenshots of the exchange you want to use as evidence and print those photographs. It is best practice to make multiple copies. Discovery is the process that lets each side of a lawsuit ask the other side for information related to the case. The discovery process is governed by the Texas Rules of Civil Procedure. These rules allow a party to ask for any information that is not privileged and is relevant to the lawsuit. There are various types of discovery requests in Texas, including requests for disclosure, requests for admission, requests for production, inspection or entry, interrogatories, and mental or physical examinations. Any discovery must be conducted during the discovery period. In Texas, there are 3 different types of discovery. Typically, the discovery begins when the first initial disclosures are due and continues for a 180-day period. An opposing party or their lawyer may challenge the evidence that you want admitted by making objections in court. The judge will respond either by sustaining the objection or overruling the objection. Sustained means that the objection was correct and the evidence should be excluded. Overruling the objection means that the evidence will be admitted to the court. If the judge overrules an objection made by the other side, you may continue discussing your evidence. Some common objections are ambiguous, argumentative, asked and answered, hearsay, irrelevant, not based on personal knowledge, privileged, misleading, and calls for speculation. Understanding objections is important because it will help you anticipate how the other party might object and how you will want to respond. We will discuss one common objection, hearsay, in detail. Hearsay is an out-of-court statement offered as evidence to prove what it claims. To be helpful, it can be broken down into 3 separate parts. It's something said or written outside of court, you're trying to use it as evidence, and the statement is being offered as evidence to prove what you're saying is true. For example, if you say, my spouse's sister told me he has a hidden bank account with $5,000, that is hearsay if you are using it to prove the bank account exists. If the other side objects to your evidence as hearsay, you may respond 2 different ways. 1, argue that it's not hearsay because it's something the opposing party said. Or 2, argue that it falls under an exception such as present sense impressions or statements describing events as they happened, excited utterances or statements made while under stress from an event, business or public records, and or statements made against someone's own interests. The judge will then decide whether to allow your evidence. Presenting evidence can be complex and intimidating, but understanding these concepts will help you make informed decisions regarding your case. If you are in need of legal advice or have any questions, you can contact the Texas Advocacy Project legal line at 374-HOPE to schedule an appointment. Thank you.